3, 2, 1, start. Release of the prisoner on bail is the prayer in the present petition, which was originally registered with the police through FIR number 21/2013 under sections 302, 109, 148, 149, PPC. Police station Drahma district DG Khan, but subsequently feeling dissatisfied with the investigation of the police, the complainant opted to file a private complaint, and in view of the learned counsel for the prisoner, he was simply required under the law to execute a bond for his appearance in the future proceedings of the complaint within the meaning of section 91, CRPC full stop. This request of the petitioner has been opposed by the complainant. Rather, Sardar Zafar Ahmad Khan, advocate, also rendered assistance with the contention that even in case of a private complainant, when an accused is summoned to face trial and if the offence is punishable with death or life, the summoned accused is legally obliged to pray for his release on bail by moving a petition under section 497, 498 CRPC full stop. In support of his contentions, the learned counsel for the complainant has mainly placed his reliance on the cases of Luqman Ali versus Hazaro and another 2010. SCMR 611 and Noor Nabi and 3 others versus the state 2005 PCRLJ 505 full stop. Luqman Ali's case Supra was decided while placing reliance on Noor Nabi's case Supra, and incidentally the learned author judge in both the judgments is one and the same full stop. The learned judge, while sitting in chambers of High Court of Karachi, expressed his opinion in Noor Nabi's case, and while his lordship heard a case involving same point when was sitting as a judge of Apex Court, after placing reliance on his earlier view expressed in High Court, the same was affirmed in Luqman Ali's case, the Honorable Supreme Court of Pakistan, while realizing that in different judgments, different notes have been struck by the Apex Court on the subject, and a reference was made to the cases of Sayyid Muhammad Firdaus and others versus the state 2005 SCMR 784, Luqman Ali versus Hazaro and another 2010 SCMR 611 and criminal appeal number 56 of 1986 Rahman Dad Sayyid Mazhar Hussain Shah, and that at different time, different high courts had also delivered conflicting judgments on the issue, found it imperative that such conflict should be removed or resolved at some early date in order to restore certainty in the matter for the guidance of all the courts in the country, leave to appeal was granted in case of Muhammad Iqbal Elias Lali Sarwar and others versus Muhammad Iqbal and others 2012 SCMR 1912, subsequent to the judgment in Luqman Ali's case, this court, in case of Haji Kalandar Khan versus the state and 6 others 2012 PCRLJ 966, has expressed in the following manner, having much regard for the dictum of law of August Supreme Court of Pakistan in the case of Luqman Ali versus Hazaro and another 2010 SCMR 611, referred by learned counsel for the petitioner, I respectfully mention here that the same is further under challenge before the same apex court. Wide criminal petition number 549L of 2011 titled Server etc. The State etc. in which, leave to appeal has already been granted and larger bench has also been constituted. Admittedly, it is century old practice qua process as provided under section 91/204, of the Criminal Procedure Code CRPC, full stop and closed.